So this is C. Ashwini Rastogi. So let us discuss what is Form 15CA, 15CB. So my dear friends, we have developed artificial intelligence chat box. This AI chat box is give you your answer. Whatever you ask, my AI chat box give you beautiful answer. Because we have developed this AI chat box given our mind so that they can understand whether these royalty, fee for technical service, what is tax as per the treaty, as per the domestic taxation, what is the tax rate. Suppose you are buying property from NRI, what is the compliances, what is the form TRC certificate, what is form 10F, whatsoever you ask, we are continuously upgrading this AI chatbot. So whatever you feel ask, you can ask from your questions. So in summary, first of all, we will discuss our presentation, then we will come up with AI chatbots. So first of all, what is Form 15CA? Basically, Form 15CA, it's a online form at, available at the SSC Income Tax login portal. So based on their information, they can fill information that is go to the income tax department. So it is a kind of declaration by the remitter. So authorized dealer banker will use that information. You have to submit Form 15CA to your AD bank. So normally this is information is go to the income tax department. So this is the online form. When Form 15CA is not required, when there is a transaction per annum is less than 5. Otherwise, Form 15CA is always required. So what is Form 15CB? It's a chartered accountant certificate because who is person who is required to certify what is the TDS amount is need to be deducted and when TDS is not to be deducted because he is expert. So he will give a CA certificate. Then on that basis, you will generate Form 15 CA Part C. So these are, my dear friends, A, B, C, D are four parts of Form 15 CA. Part A generally deals with transaction having less than 5 lakh and that is chargeable to tax. So my dear friends, important thing is when transaction is not chargeable to tax, you don't require form part A also. When it is chargeable to tax and amount is less than 5 lakh, then only 5 part A is applicable. Part B, chargeable to tax, amount is greater than 5 lakh and you have a low rate TDS deduction certificate, then part B is applicable. So my dear friends, A and B both are dealing with chargeable to tax, chargeable to tax. If it is not chargeable to tax at all, then why you will require to fill Form 15CA? So same way C part is dealing with attached with the Form 15CB. If it is chargeable to tax and amount is greater than 5 lakh, then you require Form 15CB SCA certificate. Who will certify the TDS amount, whether it is chargeable to tax, how much TDS is deducted. Then on the acknowledgement number basis, you will generate Part C of Form 15C. So Part D is applicable when the remittance is not taxable, other than payment referred to 37BB rule, right? The remittance is taxable in the nature not covered in Part A, B, C, right? Then Part D is. So we will go into detail when we will discuss AI checkbox also. These are the same thing I have discussed part A, part B, part C, all related to taxability. You are chargeable to tax and part D when remittance is not taxable. So when Form 15CB is required. The Form 15CB is not required when the remittance is not taxable at all. The remitting country of the remittance taxable remittance sent to that country. Form 15CB is not necessary if the remittance does not exceed 5 lakh. When individual make remittance not for the purpose of foreign tour or foreign asset, then Form 15CB is not required. So there must be a purpose code in Form 15CB, and there is a 33 category RBI has released for which Form 15CB is not required. The Form 15CB is required and it is specifically required by Section 195, subsection 6 for the purpose of making payment to non-resident or a foreign company. It is used to verify the payment being made comply with the provision of income tax, domestic taxation, and double tax avoidance agreement, that is treaty. So Form 15CB is required for payment to NRI or a foreign company which is taxable. My dear friends, important thing is that is chargeable to tax. Suppose you are making salary payment to non-resident, that is taxable, then Form 15CB is required. So whenever you are filling Form 15CB, so what is process is that there is a assessee portal and CA portal. Suppose assessee company want to add chartered accountant, they have to enter CA membership number in their assessee portal. So on the basis of they add the CA, the request is go to the CA. So Form 15CB usually filed by the CA only. So that's why Form 15CB is not showing in the assessee portal. So normally think that I'm giving you some basis class. So when you are filling Form 15CB, a remitter detail, name of company, PAN number, nature of business, contact detail. So these are entered by the your chartered accountant. So they have also required to enter remittee detail. Who is the beneficiary, address, country, remittance. They are also required to fill up PSR code, your banker detail, AD banker detail, a detail of remittance, country and currency, nature of transaction. Document required for DTA benefit is TRC certificate. Suppose you don't have TRC certificate in Form 10F, so you are not getting benefit of tax. So normally permanent establishment play important role in case of business income. So chartered accountant normally asks no P certificate from the foreign entity. They want to ensure that you don't have permanent establishment in India, so that your higher tax rate of 40% in case of foreign company is not applicable. So this no P normal kind of declaration, you can ask from us. We will give a link no P declaration format in our description also. You can ask. So these are the DTA benefit, additional information. Normally, when you get a TRC certificate from the foreign beneficiary, you have to get it file Form 10F with the income tax department. So, my dear friends, what is Form 10F? Usually TRC certificate in their local language. So what happens is that some TRC certificate does not contain all information. That's why income tax department has come up with a specified format of TRC that should have in TRC certificate. Usually some 10, suppose 10 criteria is there, but TRC certificate not that criteria. So you have to file Form 10F online through the login portal. You require your foreign entity PAN number also before login Form 10F. So these are 10FA, 10FB also play important role when you are applying TRC certificate in India. We will discuss when we will discuss AI chatbots. So these are the normal information I have covered a lot. These are the purpose code and the taxability of royalty fee for technical services, that is tax rate enhanced from 10% to 20%. You must take care of what is tax rate and whether you can enjoy beneficiary tax rate that is available in tax treaty. You should have form TRC certificate as well as form 10F. So on that basis, you can get a beneficial. So what happen if you don't file Form 15CA, 15CB? Normally 1 lakh penalty under Section 270, 1I is applicable. So uh, um, question arise before us whether Form 15CB can be withdrawn. Yes, if you have not linked through the UDN number, it can be withdrawn. Even after UDN number, it can also be withdrawn. If suppose Forms 15CB is generated by our chartered accountant, but Form 15CA is not generated because the client doesn't want to pay that foreign remittance. So Form 15CB can also be drawn within 7 days from the date of form submission. So these are the criteria for tax rate. The important thing is what is the tax rate available in the tax treaty. So in order to access tax treaty, you must have TRC certificate. So what is the tax rate as per the Income Tax Act? Whichever is more beneficial, that will be available to the taxpayer. So normally, surcharge cess is add-on to the income tax rate only, not in the double taxation avoidance agreement. Suppose royalty tax rate is 20% as per the income tax rate. So cess is at so effective tax rate is 20.8%. But DTA says tax rate is 10%, so no surcharge, no education cess is added. So what is the gist of section 195? Section 195 is very important section. It's play important role, even though suppose you are not liable for your tax audit, but you are making foreign remittance. You must require to deduct TDS deduction under section 195. So 195 is applied for even a single rupee payment. It does not specifically convert any threshold limit. So any individual or any company is entity is responsible payment to non-resident or a foreign company. My dear friends, important thing is made noted there. Suppose a foreign non-resident is a partner in your partnership firm. You are making payment under section 194T, which is recently covered from the 1st April 2025 as a partner remuneration. So whether 194T is covered or 195, because 195 is covered since it is a specific section in respect of foreign company or non-resident. So anything you require to pay, even though to the partner of a foreign partner who is a non-resident in your partnership entity, you require to comply section 195, not 194T. So all kind of payment is covered, interest, royalty, fee for technical services, capital gain, or any other sum which is chargeable to tax as per the Income Tax Act. So normally India follow source-based taxation. You have to deduct TDS and file TDS return in form 27Q in respect of non. So normally, if you are applying lower rate details deduction certificate, you can approach with the income tax assessing officer by filing form 30. So whenever, what are the consequences? You are not complying section 195. The thing is, first is the expenses is disallowed 100%. In case of payment to resident, the normally disallowances is 30%. So in case of NRI, foreign company, you don't have deducted TDS, 100% expenditure is disallowed. So interest is also thing. So in order to, if you are not liable for TDS as per the normal provision, but as per section 195 is required. I'm giving a simple example. You are a resident buyer, you're buying property from a non-resident who is a seller of their property in India. So ultimately, situs of tax in India. So that NRI is liable to tax in respect of capital gain income from that property situated in India. So buyer has to deduct TDS certificate, TDS deduction. So in order to TDS deduction in respect of foreign seller, foreign NRI, they must have 10 number. So 10 number and payment by the 7th of the following month, even that an resident buyer has to file form 27Q. So these are the basic crux. So yeah, my dear friends, international taxation is very cumbersome job. No one is specialized in this area. So that's why I have developed AI Chatbot. So whatever you question you feel you can ask. So normally the tax rate is this slide is 12.5% with effect from 23rd July. and it's depend upon royalty, fee for technical services, and dividend also. Normally, corporate dividend CDT is over. Now the dividend is taxable in the return of shareholder. So it's depend. Basically, it's depend on the transaction and fact of the case. International taxation give a different answer. So might be AI chatbots give a some different answer. So you must. It is advisable. You AI cannot interchange human interface. So you must take a professional advice before believe in this AI. So this is the chat flow chart. When the transaction is less than 5 lakh, transaction is not chargeable to tax. The Part A of Form 15 CA is applicable. When it is more than 5 lakh and you have a AO lower rate TDS deduction certificate, Part B of Form 15 CA is applicable. Otherwise, Part C, it is chargeable to tax more than 5 lakh and TDS is required to be deducted, then Form 15CE is required. Based on CA certificate acknowledgement number, you will able to generate Part C, Form 15CA. Normally, otherwise, Part D is applicable. So I quickly discuss my AI. So whatever question you have, you can ask this AI. So I will put a link here in this chat box. So first, my question is when Form 15 CA is required. So we ask this beautiful question from our AI chat box. You can ask your mute question, your typical to typical question related to international taxation. I will put up this link in this. So when Form 15 CB is required. Form 15 CB is required. A taxpayer is making foreign remittance outside India need to provide a CA certificate. This form typically necessary non-resident who is receiving payment from India, such as interest, dividend, royalty, fee for by default, everything he is new. I have given my mind to this AI chatbot. It is it is essential for ensuring compliances, tax regulation, avail benefit under the treaty. So another important question, what are the steps involved for TRC certificate? How to file Form 50, 10F? So normally you have a TRC certificate, so you have to file Form 10F by the foreign entity, non-resident in the by logging income tax portal. So this is the 10F steps. My AI is giving answer beautifully. You log in to the income tax portal, select this form, attach that TRC certificate, and you able to generate Form 10. So what is the tax rate for royalty? So it's depend upon whether you have a permanent establishment in India or otherwise you don't have permanent establishment. Normally, royalty is based upon the source-based taxation. If you have a permanent establishment in India, the tax rate is 40%. Otherwise, the tax rate 917 is prevail, tax rate is 20%. That increase in the last year 10% to 20%. So in order to get a beneficial tax rate, suppose your tax treaty is provide some make available clause or some narrow definition, most favored nation clause is available. Other country has given us some beneficial rate. You can borrow those narrow definition or short rate. You must have TRC certificate in order to access the double taxation avoidance agreement. So, what are the definition of royalty? So, as per the domestic taxation, as per the DTA, you must take care, uh, need to understand whether royalty is a copyright or patent software. So, everything you must take care. What are the TDS rate? I put it this question important here because always software is challenging because the software is taxable if you have your foreign entity non-resident has a PE in it. Otherwise, it is a not a IPR, intellectual property right transaction. It is a simply sale purchase business transaction. It is not liable to tax. So my AI give a beautiful answer that TDS rate on software can vary nature of transaction. So nor this is because such payment does not constitute royalty. unless the transfer of right. Because the most cases no TDS is deductible on software purchase. So this is a beautiful answer given by one of the Supreme Court judgment. Let put this question before the AI. Give me name of Supreme Court judgment and analysis. This is a beautiful answer given by Engineer Analysis Center of Excellence Private Limited versus CIT. This case law has decided the taxability of software. So whether human interface is required for the purpose of FTS. So this question is famous question. AI has given a beautiful answer to the UN model convention. The definition of FTS typically involve payment to managerial technical consultancy. According to UN model, FTC does not require human interface. So even artificial intelligence, it fall under the FTS. So what is the TDS rate in case your FTS paying to an entity, those entity does not have permanent establishment. So normally if you are making payment to an entity having permanent establishment, then TDS is required to be deducted on net amount at a 40% since you are making payment to foreign company. So otherwise, if uh, foreign entity NRI has provided you no PE certificate, the tax rate is 20% plus surcharge and education cess. So this question I have already discussed. So what is the tax rate? Suppose your FTS uh, clause in the TT has make available clause or most favored nation concept clause is there. That AI given a beautiful answer TDS or for FTS when there is a no P that then there is a P 40% and suppose make available or more favored nation clause is there rate may be lower depending upon specific term of the TT. It is advisable to go to your relevant tax professional advice. So what is the salary tax rate in respect of you are making payment to the NRI who is an employee of your company. It is generally tax rate based on slab rate, whether it is new regime, old regime. It's depend upon you do analysis as per section 192, not fall under section 195. So what is TDS rate in respect of dividend payment by the Indian company to the foreign non-resident? So TDS on dividend to a non-resident by the Indian company is generally 20%. This AI is also giving beautiful answer of 5%. You must read. However, if the DTA is provide 5% lower rate, India, Mauritius DT, you can avail that benefit. You must check whether TRC certificate is available. So what happens is that India, Switzerland had suspended the MFN clause in January 2025. So what impact is that? The suspension of MFN clause in India, Switzerland treaty effective from January 2025, it's lead to liable for higher rate, not 5%, which is available in the in Switzerland, Netherlands, or France treaty. So right now there is a 10% rate which is available as per the treaty, not go to the MFN clause. So this happened after suspension of MFN clause by the India by the Switzerland government in respect of India Switzerland treaty. So, my dear friends, I have question a lot. You can ask your question based on your expertise, based on your fact of the case. Suppose you are making payment for import of payment, whether SEB provision is prevail. Yes, this given a significant economic prevalence purview. Same way, equalization levy that has been abolished with effect from April 2025. So normally 6% Google tax is applicable, 2% Amazon tax is applicable. But with effect from 2025, this AI, equalization levy has been abolished. And second thing is that I have asked what is the TDS rate in respect of equalization levy. That is not covered by the income tax act. That is covered by the finance act. So there is no TDS, no form of levy in respect of equalization. So what are provision in respect of residency? Because residency is depend upon your residential status, how many days you stay in India, whether 182 days, 60 days, you know, last 4 years, 365 days. It's depend upon additional condition, 2 out of 10 year. What is your residential status, whether RNOR or ROR, additional condition you need to check in order to ordinary status and last 7 years. So these are the basic things. So suppose another thing is this AI is also discussed beautifully. Suppose your income from Indian sources is more than 15 lakh and your stay is more than 120 day but less than 182 days, then it is deemed residency. Same way, if you are an angel person, stateless person, it is a deemed residency. You go around the world 40 day, 50 day in particular country, 40 day, but no one country you devoted more than 182 days, but your Indian source of income more than 15 lakh, your status in India is RNOR. So your Indian source of income would be tax. Suppose a NRI doctor who is running hospital in India depends upon he give some advice over the phone or over the camera. Uh, he stay in Dubai. So what is their professional income? It is liable to tax. So same way this question can be chartered accountant based or advocate based. Same way, I have important question is that in respect of NRI who is selling their property in India after 23rd July. So 12.5% without indexation taxes there. That is in respect of long-term capital gain. Suppose you are selling before 23rd July, the tax rate is 20%. Yes, you can go for exemption. It depends. So suppose you are selling some DLF flat for 10 crore 12.5% because you bought this property before 23rd July, selling after 23rd July, you do not eligible for indexation benefit. Simple 12.5% on entire sale consideration on 10 crore. 1 crore 25 lakh TDS need to be deducted by resident buyer or non-resident buyer. So this AI, even though given a beautiful answer. Another question is that suppose NRI selling his property in India, what is the tax rate in respect of short-term capital gain? That is slab rate. So this is the period of holding 24 month is given. It's normally depend upon the your slab rate. The normal tax rate is 30%. This is the correct answer. Yeah, my AI given. So I have trained this AI by giving a very different kind of concept by filing, giving all thorough knowledge and asking each question from this AI. Then this AI is able to give me correct answer. So I have asked this question, if buyer is buying property from resident, then this AI is giving beautiful answer from the perspective of domestic taxation 194 IA 1% in case of more than 50 lakh. You need to deduct TDS on property. Suppose a non-resident is buying property from after 23rd July, so 1%. Even though non-resident buy property from resident, 1% is applicable. My dear friends, most of our chartered accountant is confused with this question, but AI is giving a beautiful answer. So I urge from my fellow colleagues, you must use this AI and give me your observation, give me your comment. I will be honored if you give some suggestion. This AI I will implement. This is my first step in India to teach international taxation to my AI chatbot so that anyone want to use. So this question I put up, suppose NRI selling his property to another NRI, 12%, 12.5%, not 40%, but it's giving let me teach, I will. Uh, Suppose NRI selling to another resident NRI is selling in respect of his capital gain, 12.5%. So this question is related to TDS. So 1% is need to be deducted by NRI. So this is the correct answer. So my dear friends, I covered up entire gamut of international taxation, particularly related to Form 15 CV. Even I given this AI chat box to you. If you have any question, you ask, but don't depend upon artificial intelligence. Always take care from professional advice because no one can interchange human interface. माइंड है और AI सो मैंने अपनी तरफ से बेस्ट दिया है फ्रेंड्स। आपके 15 सीवी से रिलेटेड 15 सीए से रिलेटेड कोई आपकी लीगल ओपिनियन भी हो सकती है कि इस पे टैक्स एप्लीकेबल होगा कि नहीं होगा, तो वो हम अलग से वो भी हम ड्राफ्ट कर सकते हैं। तो थैंक यू माय डियर फ्रेंड्स।